All right. In fact, we have some more inputs on the story. Members of the Women's Congress are currently protesting outside the Supreme Court ahead of the hearing on the 2017 Unnao rape case. Let's in fact listen to what one of the protesters had to say.
ये हमें घसीट रही है पुलिस, हम बेकसूर हैं। दिल्ली प्रदेश की अध्यक्ष हूँ महिला कांग्रेस की, हम बेटी के लिए आए हैं तो हम उसके लिए बात भी नहीं कर सकते। हमने नारेबाजी की तक कर दिया। ये देखिए कैसे खींचा जा रहा है, कैसे मारा जा रहा है। ये हम एक बेटी जिसको कुलदीप सेंगर की क्यों नहीं पकड़ती? कुलदीप सेंगर को क्यों नहीं पकड़ी? इनको बोलो। अरे मैं दिल्ली प्रदेश की अध्यक्ष हूँ महिला कांग्रेस की, मैं ये पूछना चाहती हूँ ये पुलिस कुलदीप सेंगर को क्यों नहीं पकड़ रही? आपकी बहन बेटी होगी ना वो। ये हमें घसीट रही है पुलिस, हम बेकसूर हैं।
All right, so you can see that there are people over there protesting outside the Supreme Court. They seek justice for the survivor of the Unnao rape case. They are supposed to be members of the Women's Congress. In fact, joining us on the phone line is Brinda Adige, women's rights activist. Thank you so much, ma'am, for joining us on the broadcast. A very good morning to you. Ma'am, we want to understand, this is a very important plea that has been filed by the CBI in the Supreme Court. We have been seeing a lot of protests by people. There was a lot of outrage when this entire Delhi High Court observation had come and suspension had come in of the life sentence.
You're absolutely right. And now when the courts say that they did not find the threat perception so serious, and that is why the convict Kuldeep Singh is being, the sentence is being suspended, just goes to show that the victim and her supporters are now fighting against political influence and institutional failure. Should the system not be put on trial along with the accused convict over here? Why is it that the courts are not asking those questions? Procedural lapses that they are talking about is a process of law. That shouldn't be the burden on the survivor. Where else will the survivor go? Courts are our last resort. We cannot go anywhere else. Courts cannot place that burden on the survivor. So it is important today that the Supreme Court looks at all these things, because this is part of the constitutional guarantees that every citizen in our country has a right to. So the CBI's plea, appeal in the Supreme Court must be looked at in that light. Not in saying when he was accused, he was not a public servant, because they must go through the various judgments that talk about who is a public servant, which has been very clearly defined. And I think the Supreme Court cannot go and say, no, I don't like that definition, I'll go by this definition. Absolutely wrong, because this is a systemic failure and there is immense political clout, immense political influence. You cannot expect an ordinary citizen to fight all of this when the truth and justice is on her side. And we are fighting, asking the courts to look at something like this. What are the courts there for? The courts are there for citizens. And people sitting there and doing the work are all sarkari naukars paid for by our taxes. So we the citizens have a right to hold them accountable.
Absolutely, ma'am. And when you are looking at such a case, it also, raises many questions, because this person, even though he was not released from jail because he is convicted in another case where he is serving the 10-year jail sentence, but the whole question actually points, if that other case was not in question, he would have been a free man till the judgment actually came in this entire case.
You're absolutely right. He would have walked out free rapist, murderer. He would have walked out free if it wasn't for the other case. But another point to consider over here is the order given by the judges also sets a very dangerous precedent. Now you will have every rapist, every convict, every murderer coming out and saying, please suspend my sentence for ABCD reasons. I think the Supreme Court must strike down that order and say, strike it off the books. It's not something that's going to be talked about. It's not something that's going to be discussed, and it is not something that can be used by anybody else for future cases.
Absolutely. I think that is an important point, that it should not be used or set an example with going forward, because we deal with such cases, and we are talking about this case only because of the amount of attention this has in fact gotten. Ma'am. All right. Thank you so much, ma'am, for joining us on the broadcast. But this is currently what is happening outside the Supreme Court. We have people who are protesting, members of the Congress, women members of the Congress protesting outside the Supreme Court, seeking justice for the survivor of this case. In fact, as the Supreme Court bench is set to hear the CBI petition challenging the Delhi High Court's decision, let's take a closer look at the contended order by the High Court, because this is something that is being discussed, and why this has become so controversial is very important to understand. So let's look at that Delhi High Court judgment where we will see that he has been suspended, his jail term has been suspended. So 7.5 years for this crime is enough. Remember, he is a convict in the Unnao rape case. And now offence, what the Delhi High Court judgment says, that offence under section 5 of POSCO is not attracted, and hence appellant cannot be sentenced for remainder of his life. So they have mentioned that this cannot be come under section 5 of POSCO. Remember that the victim was a minor when this entire case actually occurred. However, the Delhi High Court judgment has stated that that section of POSCO cannot be implemented, and hence he cannot stay in jail for the remainder of his term. Now, the Delhi High Court judgment has also stated that the contention that investigation was compromised cannot be a ground not to suspend the sentence of the appellant. So, another thing that everyone has been talking about, we heard it in one of the statements as well that we were showing to you, that there is a lot of political clout involved, and hence they had put in a clause that you cannot expect that state judgment will be offended or compromise that entire investigation. So you cannot stay it on that front. Now, the trial court erred by ignoring records of government schools which show that the victim was not a minor. So now it has also pointed out that in the trial court order which had actually sentenced him, they actually made a mistake because they didn't look at the government school records where it showed that the victim might not have been a minor. Remember that this is all the Delhi High Court judgment that I am reading out for you. Now, offence under section 5C of the POSCO Act is not made out against the appellant on account of him not falling within the definition of a public servant. So it's also stating there is a particular section in the POSCO Act that deals with public servants. They are stating, the High Court is stating, the judgment, that he does not fall under that purview, and hence we cannot apply that section of POSCO on him. And lastly, the Delhi High Court actually said that since appellant has already undergone 7 years, 5 months under incarceration, which is more than the minimum number of years. So the Delhi High Court finally, before suspending that jail term, stated that he's already served 7 years, 5 months in prison. This is more than the minimum number of years that he needs to spend, and hence we can in fact look at suspending his sentence further. All right, to discuss this further is Advocate Jasmine Damkewala, who is joining us on the broadcast. Thank you so much for joining us on the broadcast. Advocate Damkewala, if I can come across to you. We were just trying to understand that Delhi High Court judgment. They have stated a lot of things. They stated that section 5 of POSCO is not applicable in this case. They have also raised the issue of the trial court erring because they did not take into account the government school details of the minor involved.
Yes. Thank you for having me, first and foremost. Second thing is, see, basically it is a technicality which came in the way of justice here, because with due respect, what the Honorable High Court has said is that because of the minimum number of years, it has already been, in custody, then he should get that benefit, and for that reason, this ruling has come about. But see, technically, it may not be incorrect; it is correct. But fact of the matter is, sometimes we expect that courts would mold the relief in such a way that justice is served. Because here, if you see, there's a lot of public sentiment against the ruling. That is because somewhere people feel that he got away. If he had served that sentence after being pronounced and in custody, not just in custody, he would have probably been serving the sentence in prison, then the public sentiment would not be this way. But this public sentiment is because as an under trial itself, he served that much time, which is not really a punishment because the sentence has not even started. So because of the public sentiment, we feel that maybe a relief should have been molded. But technicality doesn't get in the way. Let us see what the Honorable Supreme Court says today. We are all waiting for the verdict.
In fact, ma'am, when we are looking at this, obviously we are seeing a lot of protests and we are seeing a lot of outrage as well over the suspension of the sentence. How do you look at that? And hence the CBI also filed this special leave petition.
Basically, the protest and the public sentiment is also because of the fact that this is a young girl who was involved, and there has been a little bit of a discrepancy on whether she was a minor or not a minor, but she was a young girl who was involved here, and it is public sentiment is very natural because this is a very bad. It causes a very bad message to the public at large. So that a person can get away with this. So for that reason, public sentiment is expected. It is not incorrect because we have a lot of everybody has a lot of hope. See, as lawyers, we are part of the system of justice. But the common man may not be a part of the system, but yet he has a lot of hopes from the system. And sometimes when technicalities come in the way, those hopes get shattered.
Absolutely.
So, with due respect to all that was involved, somewhere people have felt that justice is not being done. And they're not completely incorrect, because if a technicality comes in the way of justice, then we hope that courts find a way to reach justice and cross over the technicality. So that's it.
And ma'am, can you help us understand what can be the outcome through these special leave petitions for the understanding of our viewers?
See, essentially, special leave petition is not severely an appeal, but where there is no appeal, you can file a special leave petition. So if the special leave petition is allowed, then we hope today notice is issued in those and stay is granted. So that will put a stay on the impugned order of the Honorable High Court. So that is what is expected.
All right. Thank you so much, ma'am, for joining us on the broadcast. Meanwhile, we have some more inputs on the story. The CJI-led bench of the Supreme Court has assembled ahead of the hearing of the CBI's petition against Delhi High Court's relief for convicted rapist Kuldeep Singh Sengar. Joining us on the broadcast is my colleague Sambhav Sharma with more on this. Sambhav, the Supreme Court hearing has begun for the CBI. Special Solicitor General Tushar Mehta has also reached the Supreme Court.
Well, what is the latest update from the Supreme Court in this particular case is that the bench, the three-judge bench, which is to hear this particular Unnao case, the CBI's petition challenging Delhi High Court's order. This particular case, the bench is assembled, is what is the latest. However, the matter is not taken on board so far. I mean, it could come any time as we speak, because bench has already assembled. Another matter is being heard in the Supreme Court, court number 1, as we speak. If we talk about the top lawyers in the top court of the country, in the court number 1 of the Supreme Court, where this particular hearing is to take place, Solicitor General Tushar Mehta, who is appearing for the team led by a team of CBI. So here Solicitor General is appearing for the Central Bureau of Investigation, and another lawyers various lawyers. The whole court number 1 is jam-packed, and the hearing in this particular crucial case is to begin any time from now. And this is what is the latest so far. And also a small protest was seen outside the gate number D of the Supreme Court, where slogans were chanted for justice outside the gate number D of the top court. Many activists are also present in the Supreme Court as we speak, including Yogita Bayana and some other activists in the Supreme Court media lawns. They are present, and hearings to begin any time from now. And,
absolutely, Sambhav. In fact,
however,
let me also introduce this to the viewers, that the Supreme Court is hearing